Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.
Welcome to the podcast.
Right. Good morning, everyone. Thank you all for joining us today for Mulcahy Law's May live virtual First Friday event. That's a mouthful. I bet you're all likely expecting to see Beth Mulcahy in her usual seat today, but Beth does have a business conflict today, and so she can't be here, but we don't skip a beat around here. So today's First Friday will be presented by myself and attorney Madeline Gegg with our firm. So let's go ahead and start today with a few procedural matters for First Fridays. So as a friendly reminder, if you haven't already done so, please submit your questions in the Q&A box on Zoom or in the comments section on Facebook Live as soon as possible. And then we will be answering all questions between now and 10 a.m. Now, due to the large volume of questions that we receive, this free opportunity is limited to one question per association. And if you do plan on submitting a question live during this session, please include the name of your HOA or condo and your current role when you submit that question. Please also note that we may need to answer some of the live questions today. The ones that come in today, we may be answering them after 10 a.m. Via email due to the large volume of questions that we receive. So thank you for your understanding. Okay, so just to go ahead and jump into it, my name is Haidyn DiLorenzo. I'm an associate attorney with Mulcahy Law Firm. As a little bit of background information, both myself and Madeline are associate attorneys at Mulcahy Law Firm. I've been with the firm for several years now, and I'm a graduate of the Sandra Day O'Connor College of Law at Arizona State University. I've very much enjoyed working with HOAs and condos during my time at Mulcahy Law Firm to help solve some of their legal problems and issues. And now, just before we get started on all of our questions and answers, I'm going to go ahead and pass the mic to attorney Madeline Gegg, so she can go ahead and introduce herself.
Hi, good morning, everyone. Thanks for the introduction, Haidyn. Like Haidyn said, I'm an attorney here at Mulcahy Law Firm. I just joined here recently. I'm a recent graduate of the James E. Rogers College of Law at the University of Arizona, and I'm thrilled to be here. I'm working really closely with Haidyn and with Beth, and I'm thoroughly enjoying this area of practice. So I look forward to getting to know many of you, and I look forward to helping out answering some questions today. Thanks for being here for our firm's live virtual First Friday event. Like Haidyn said, that's a mouthful. And let's get to today's questions.
All right. So I will go ahead and get started on those questions. Diving right into it, we'll start with question number 1, which is from a board member. This question states, we just held our annual meeting. At the actual meeting, our community manager provided us with a tally of the online vote, but did not give a count on approval of the previous year's minutes. Thus, one of the volunteer ballot counters and a retired lawyer squawked the ballot count for minutes as short on making quorum. Our community manager said that she's had another HOA run into the same thing, and that at the next annual meeting in 2025, we could ask the approval of minutes for both years. Is this legal and valid? Okay, so the answer to that is going to be yes. It is legal to handle it in this manner. Okay, so our next question is also from a board member. This question states, our HOA is approaching annual elections, and my question is about electronic ballots sent to members. Are electronic ballots allowed for use at an annual meeting? So the answer to this is yes. Pursuant to ARS section 10-3708, a written ballot may be delivered via an online voting system, so long as the voting system, 1, authenticates the member's identity, 2, authenticates the validity of each electronic vote to ensure that the vote is not altered in transit, 3, transmits a receipt to each member who casts an electronic vote, and 4, stores electronic votes for recount, inspection, and review purposes. So several companies now provide safe and reliable, secure online voting services, which are designed specifically for HOAs and condo associations, which will also comply with those requirements that I just mentioned. So if you are looking for a list of these kinds of service providers, please go ahead and contact our firm and we can get that over to you. Just another note, online voting can reduce costs associated with the voting process and increase voter participation due to ease of use. However, please note that even if the association utilizes online voting, it still must provide an in-person voting option. So that's just something to be aware of. And then I think we're also going to get that statute shared in the chat box below. So feel free to check that out. Okay, the next question we have is from a homeowner. This question says, can an HOA board double the impact fee, raising it from $1,000 to $2,000 when the original community agreement from years ago states the board can raise this amount $25 a year at their discretion? Nothing is listed in any other governing documents in regard to this. Okay, so when you say impact fee, I'm assuming you're referring to a transfer fee or a capital improvement fee. So whether or not your board can double the impact fee without owner approval is going to depend on your association's documents and what they state. If the documents allow for this action by the board in this amount, that's likely permitted. However, based on the question that was submitted, it does look like the amount that they were permitted to raise it by was capped at $25 a year. So it does appear that there was a potential violation there. So our office will go ahead and share the cheat sheet that we have on transfer fees. So we'll share that with you in the chat below if you'd like any more information on that topic. Okay, these are good questions. So the next question is also from a homeowner. So this says, my HOA board ran an RFP process for a new management company. The board did the work and evaluation negotiations themselves outside of the regular board meetings. The existing management company was not involved. A number of homeowners wanted to know more about the candidates and their proposals. A records request was made to the current management company. Here is their response. Management is not in possession of any such documentation. As you know, emails are considered transitory in nature and are not saved as records of the association. The same is true for bids. Only approved proposals, contracts are kept as records of the association. We would like to see some of the detailed emails back and forth with the two finalists clarifying the services they would provide. The board would not share them. Are emails between board members considered records of the association, and should they be made available to a homeowner through our records request? So this is a good question. The answer is going to be yes. If your board or association still has RFPs or emails related to the management company selection process, the board is required to share these documents with any owner that requests it. So the law that supports this is going to be ARS 33-1805 for planned communities and ARS 33-1258 for condominium associations. The language of this law, it's going to state all financial and other records of the association must be made reasonably available for examination by any member or any person designated by the member in writing as the member's representative. An association cannot charge a member for making books and records available for review, but can charge 15 cents per page for copies of records requested. An association has 10 business days from the date of receipt of a request by an owner or an owner's designated agent to make the records available or to provide copies of the requested records. Okay, moving right along here, we have another question from a homeowner. This question states, we are self-managed. Our board is doing all kinds of decision-making outside of board meetings. We have a 5-member board, and one board member is not included in any of the decisions or discussions. He openly says at the board meetings that he was not aware of the decisions that were being made. When there are board meetings, the board announces decisions that have been made about things like landscape maintenance, potential new landscape companies that are being considered, creation of committees, etc. The outcomes are simply announced at the board meetings without any community discussion. We assume that these things are either happening by email or by phone calls. Is the board in violation of the open meeting law? So based on the facts you provided, yes, it does appear that the board is violating the Arizona open meeting law because the quorum of the board is meeting outside of a board meeting and not giving the owners 48 hours notice of that meeting. So our office does have a great cheat sheet on open meeting law, which we will share on Zoom and Facebook Live now. So feel free to check that out for some more answers on open meeting law requirements for associations. All right. Our next question is from a board member. Our antiquated CC&Rs provide no guidance for the problem of parking multiple cars on the street, occluding the flow of traffic, including EMS. The fire department says it's not their problem. They will just drive through whatever is in their way if needed. As a stopgap until we can afford to amend our CC&Rs and bylaws, can the board make a rule that says residents and guests must park only in front of their own units or in their garages? So this is a great question. This is essentially going to depend on the authority that your documents provide the board for rulemaking. So if your association's documents provide the board with broad rulemaking authority, then they'd likely be able to do this. But I would probably need to take a closer look at your association's documents to know that for sure. Okay, next question is from a homeowner. It says, I'm new to our present community and a past treasurer from my prior HOA. I have asked the management company about their $250 statutory fee. We didn't pay such a fee to other management companies. Their response stated, the $250 fee is our fee to the management company. A portion of that fee does go to the Arizona Corporation Commission. This is a common practice for a corporation, LLC, and any other business entity. If they desire another business or organization to accept legal documents on their behalf, they charge a fee for that service. Like I said before, without this fee, we will not be able to accept any legal documents on your behalf, end quote. Is it true that this is a required fee? So in my experience, it's not customary or legally required to charge that $250 fee that's mentioned. For example, our firm is a statutory agent for many associations that we represent, and we don't charge a fee like this. All right. Next question is from a community manager. This states, our CC&Rs prohibit parking in the side yard. The streets are narrow, and there are many big trucks in the community, as well as box trailers, boats, etc. We cannot enforce street parking. I have homeowners that are now parking the box trailers, boats, and horse trailers in the street. What is the best course of action? Since your association can't enforce street parking, one thing I'd recommend is potentially reaching out to the police department or the code enforcement department of the city you live in to see if this is a violation of city code and if they will go ahead and enforce it. And then just as another note, if this is kind of an ongoing problem, the association may want to consider taking a look into potentially updating its documents to provide better regulations for parking that will better serve the association. Okay, next question is from an owner. This question says, can the board authorize the use of reserve funds for non-emergency use voted on via email without ratification at an open meeting? Use was discussed at an open meeting, but not sure if this constitutes ratification. So since this wasn't an emergency, utilization of reserve funds or voting on use of reserve funds should have been done in an open meeting and probably not voted on via email. So to learn a little bit more about open meeting law, we will have that cheat sheet again. We'll provide that in the chat below, but that should provide a little bit more information on that for you. Okay, next question is from a board member. This question states, what rights do HOAs have to protect against fraudulent documentation for supposed emotional support animals? We know how easily one can buy fake documents on the internet. Okay, so this is a good question, and this is, an area that we get a lot of questions on. It's kind of a tough question because it's hard to prove that someone has fraudulently obtained documents for an emotional support animal. I think the board should probably look at each request for an emotional support animal on a case-by-case basis and also consider consulting with the association's legal counsel if the board does believe that there's some fraud happening there. So just a quick recap of the Fair Housing Act, which will pertain to assistance animals in general. So even if a community association has a no pet policy, an occupant may be permitted to keep an animal as a reasonable accommodation. To be protected by the Fair Housing Act with regard to assistance animals, the following factors must be met. So 1, the person must have a disability. 2, the assistance animal must serve a function related to that disability. And 3, the request to have the assistance animal must be reasonable. Disabled residents can request accommodation for most types of animals for non-emotional support. To comply with the Fair Housing Act, the association can require a resident to provide proof of the claimed disability from a physician, unless the disability is obvious. or a parent are already known to the association. The association can also require a physician's statement that the animal is necessary for the resident's disability. And then it can also require the resident to follow policies for the cleanup of animal waste, leash requirements, or any other rules regarding pets within the association. So it's important to note that the fair housing allowances for assistance animals is separate and distinct from the ADA's requirements for a more highly trained specific service animal. So these are just slightly different. The FHA does not require an assistance animal to have any specific training. Okay, so for the next few questions, I'm going to go ahead and turn this over to Madeline, so she will take over from here.
Thanks, Haidyn. So next question, number 11, is from a future board member. And they ask, is it normal or legal for an HOA board to be able to special assess owners $3,000 to $4,000 without a community vote? Is it odd that this is not addressed in any of the governing documents? The short answer would be that yes, this is odd. It really depends what an association's documents state as to whether that is legal or allowed. If the documents allow a board to do that, then likely, yes, it is legal. Next question is from a former board member. The CC&Rs state that the board shall consist of 3 members. There was an opening on the board and they asked for volunteers. 2 owners volunteered and they appointed both, making a 4-member board. Since there was no quorum for an annual meeting or election, again, the 2 original members maintained their position along with the 2 new appointees. Is 3 members or 4 members correct? The management company is taking no position on this matter, letting the board do what they want to do. There has been no annual meeting for 5 years. So the answer is that if the CC&Rs state that there should be 3 board members on your board, then there should only be 3. So the board may want to discuss this and then potentially have one person voluntarily step down so the board is in compliance with the CC&R requirements. Okay, this is from a homeowner. We recently had our annual meeting. We have 5 board members. 2 were new. The president announced that she would continue as the president, named the other officers, and made a motion to approve. Another board member seconded. One of the new board members asked about discussion. The president said that the board would not be discussing who the officers were because she already made a motion and it was seconded, so it was time to vote. Should board members have the opportunity to discuss or clarify before voting? Yes, the board members and any community members as well who want to contribute on any matter that's being voted on should be allowed to say something before the vote. The kind of proper procedural way for this to happen is to first have the motion for something to be voted on, then a second, and then in between that second and voting, we would have a little discussion on the motion, and then last, a formal vote. Okay, question 14 is from a board member. We have a recorded assessment lien on a homeowner. Does it ever need to be updated or renewed? The answer is that most liens have continued lien language in the lien itself, so it likely doesn't need to be updated. Thanks. Question 15 is from a board member. The levying and collecting fines cheat sheet says that to collect a fine, an association has to file a lawsuit against the owner, then obtain a favorable judgment, and finally record the judgment with the county recorder's office. Still, the association cannot collect the fine until the property is conveyed or sold. That seems like it will cost a lot more in legal fees than an association can ever recover in fines. So isn't a valid monetary penalty or fine policy and schedule kind of unworkable from the get-go? The short answer is yes. And for that reason, we only sue on fine amounts that are higher than $750 because we will have to end up spending money in legal fees to get that judgment. In pursuing that judgment, one of the goals is also to recover attorney fees. Next question is from a board member. Our community has an additional monthly HOA dues for the paired and attached homes or townhomes to cover the future cost of maintenance, repair, and replacement of the exterior paint, stucco, and roof tiles of the dwelling unit, which is stipulated in the CC&Rs. Can the board or a vote of the homeowners have the CC&Rs change or remove this stipulation and related additional HOA dues? The answer is no. The CC&Rs would need to be amended to change this, and your CC&Rs will have a procedure in it to establish how an amendment should be made. Next question is from a resident. We are told that the transition from builder to residents will start in the next several months. Currently, the residents only deal with our management company and have no direct contact with the board of directors. We can't find out who is the legal representation for the HOA. The question is, when is the best time to get legal advice since we have not resident board of directors representation right now? Also, your cheat sheet indicates that there's a time period to file any claims towards the builder. Can you tell me what those time periods are? I would reach out to our firm to get some advice on the transition process because it can be kind of sticky and challenging to navigate if you don't have legal advice. And I also recommend that you review our cheat sheet on the transition from developer to owner control. The deadlines to sue the developer are 2, 6, and 8 years, and that will just kind of depend on the circumstances. Next question is from an owner. Do you feel HOA should be incorporated? And if yes, why? Answer is yes, absolutely. And the main reason is to limit the liability of its members. Next question is from a board member. Our association has updated its rules and regulations in accordance with our CC&Rs, including a review by the association's attorney. We are aware of the legal requirements of enforcement, and a major concern relates to the renewed enforcement of common violations that have been unenforced for many years. For example, more animals than allowed, larger dogs than allowed, personal seating in common area, landscaping, personal decor, etc. I'm looking for practical suggestions on how to ease into compliance compassionately yet forcefully. Those who follow the rules feel a sense of inequity, but those who have been in violation feel that they are grandfathered in. Strict compliance throughout the community would yield several hundred violations on day one. Even with a reasonable cure period, it seems harsh to tell owners that they have to get rid of family pets. What are your thoughts on enforcement steps to resolve this peacefully, reasonably, and equal for everyone? This is a tough question. So I think you need to look at violations on a case-by-case basis and really involve the assistance of your legal counsel. How long have violations existed? How practical is it to ask the owner to cure the violation and kind of go from there? Question 20 is from a board member. At our annual organizational meeting last month, 3 new board members took the oath of office and pledge of confidentiality. However, the 4 current board members who were either appointed to fill a vacancy or elected did not take the oath of office or pledge of confidentiality. They said they took it last year and felt that they did not need to take it again. Was the meeting invalid? I think that all board members, new and old, should take the oath and pledge each year if this is kind of something that your association does and is part of your standard procedures. But I don't have enough information to determine if the fact that they didn't at this meeting makes the entire meeting invalid. So you may have to reach out if you have more questions on that. Question 21 is from a board member. As an HOA of 44 residents, are we required to have a yearly formal outside reserve account audit? The answer is that many boards contact our office and ask if an association is required to have an audit done by CPA every year. And it depends. First, you need to examine and review your association documents, the CC&Rs, articles of incorporation, your bylaws, and see if the documents address the need for an audit. If so, the association needs to follow exactly what the documents state. Arizona law also addresses this topic. Pursuant to Arizona law section 33-1810 for planned communities and 33-1243 for condominiums, a board of directors is required to conduct a financial audit or review or compilation of the association annually. The annual audit, review, or compilation shall be completed no later than 6 months after the end of each fiscal year, and the results of such audit shall be made available upon request to the members 30 days after the completion. Under Arizona law, if the association's documents require an annual audit by a certified public accountant, then the association must hire a certified public accountant to conduct the audit. If the association's documents do not require an audit by a CPA or don't mention the need for a review or compilation, then the board must conduct a review or compilation for each fiscal year, but not necessarily through hiring a certified public accountant. Anyone, such as a bookkeeper, committee, treasurer, board member, management company, etc., can conduct this review or compilation. However, the best practices dictate that an independent person should be the one conducting this review or compilation. It's a good idea for association to complete a verification of completion of annual financial audit review or compilation every year, a sample verification form can be found on our website. And if your association needs a referral for a CPA for this purpose, please feel free to contact our office. We have a few. All right, question 22. This is from a board member. Our rules of association, we have a tenant registration form with a $25 fee. The tenant is defined as anyone living in any townhouse in exchange for monetary or material consideration or any non-deeded owner in the residence. Does this also apply to short-term rentals? What is your recommendation for carrying this out? Over the past few years, there has been a dramatic increase in the number of rental properties in Arizona, including short-term and vacation rentals. And so I'm just going to give you a quick rundown of what an association can require from a landlord regarding the tenant. Associations are prohibited from requiring any owner to disclose to the association any information regarding the tenant other than the following. And just so you know, this is from Arizona law. It's ARS section 33-1260.01 for condo associations and ARS 33-1806.1 for homeowner associations. Associations can require the landlord to disclose the name and contact information for any adults occupying the unit, the time period of the lease, including the beginning and ending dates of the tenancy, and a description and the license plate number of the tenant's vehicles. If the association is an age-restricted community, the owner's agents, or the tenant must provide the association or its manager with a government-issued identification document that has a photograph of the tenant and confirmation that at least one of the tenants meets the association's minimum age requirements. In providing this information about the tenant, the association may charge the owner a fee of not more than $25. The fee may be charged for each new tenant, but it cannot be charged if the same tenant renews the existing lease. These restrictions apply to short-term and long-term rentals in Arizona, so your association's tenant registration form must comply with these requirements under Arizona law to be enforceable. Mulcahy Law Firm encourages board members and managers to review our popular and informative cheat sheet on how to work with rental properties to assist you in navigating your rentals in your community. We're here to help you, so please feel free to reach out to the firm if you have any rental-related needs. We know it can be kind of a complicated and seems to be always changing area of law, so feel free to reach out. And then this will be our last question that we're answering live here, I believe. This is question number 23 from a board member. From one of the directors, they told us they just watched a seminar, class 2 from 2022, and recommends it for all board members. So thank you for that recommendation. And they said that they are currently not in compliance with the law and not letting the members of the community see the agenda 48 hours before the meeting. ARS 33-1804, subparagraph E, part 1 says the agenda shall be available to all members attending. Is that the law today, or that the agenda must be available at the open meeting and not that the agenda must be available 48 hours before the meeting? Perhaps this might be a best practice, but not a legal requirement. So this is a really great question because the law is changing in this area. So Arizona law currently only requires that the regular board meeting agenda be provided to all who attend a regular board meeting. However, there is a bill in the Arizona legislature that was just signed by Governor Hobbs this year. This is HB 2662, and this will require that all meeting agendas will be given at least 48 hours in advance of the board meetings by newsletter, conspicuous posting, or any other reasonable means as determined by the board of directors. This new law will go into effect 90 days after the legislative session ends. So that will likely be late summer, early fall this year. And associations will be required to comply with the law at that point. Okay, that wraps up our questions that we'll be answering in today's live virtual First Friday event. I will turn it over to Haidyn for closing remarks. Thank you.
Thanks, Madeline. And thank you to all of you for joining us for today's live virtual First Friday event. There were some really great questions today, so thank you for everyone who submitted questions. Once again, if we didn't get a chance to answer your questions on today's live, we will be reaching out to you via email to answer those questions, so be on the lookout for that as well. Just as a reminder, this month, class number 5 of the 2024 Virtual HOA and Condo Academy is set for Tuesday, May 21st at 11 a.m. The topic for this class is Charting Your Course, a comprehensive guide to board roles and responsibilities in HOAs and condos. So in this class, we'll cover the roles, responsibilities, and risks and fiduciary duties of board members in an HOA or condo. So be sure not to miss that. You can also visit our website, www.mulcahylawfirm.com, for any more information about our classes and those HOA academies. And I think that's pretty much all we got for you today. So thanks again for joining us, and I hope you all have a great weekend. Thanks, everyone.
Thanks, everyone. Have a good one.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review.